everyone, and welcome to the Jus Commune podcast. My name is Emilia Ferrandez from the International University of Catalonia in Barcelona. And today I have the pleasure to have as guest Professor Stefania Gialdroni from the University of Padova, Professor of Medieval Law, and the PI of the ERC project MICOL, Migrating Commercial Law and Language. So I would like to begin with a basic but essential question to introduce our listeners to the topic of this episode. What is the Lex Mercatoria according to traditional scholarship?
Thank you very much, Emilia, for the invitation and for this question that seems to be easy, but it's not easy at all, because I think that when we talk about the Lex Mercatoria definition is very important, and you will better understand what I mean, I hope, in the course of this interview. So, to be very brief, I would say that we can define the ancient Lex Mercatoria as a uniform and universal customary law used by merchants, at least in Europe, and at least from the late Middle Ages until the modern period. I said at least because some scholars, especially at the beginning of the 20th century, sometimes expanded this idea of Lex Mercatoria outside the boundaries of Europe. Some scholars add to this body of customary laws also guild statutes and mercantile courts' decisions. But even on this point, there is no unanimity. Can I say something more about this? Yeah?
Yes, of course.
Okay.
Go ahead.
So before delving into the topic of the Lex Mercatoria, I would like to underline that the very expression that we use a lot also today was unknown, as far as I know, outside the boundaries of England until the 20th century. So we cannot find these sources on the continent. We can find the expression in the title of a book included in another work, which is called Little Red Book of Bristol, which is a collection of texts dated especially to the end of the 14th century, thought for the merchants of Bristol, like oaths, statutes, privileges. And this book, inside the book, was entitled Incipit Lex Mercatoria. Then, for like 350 years, nothing, until a work which is quite famous for scholars interested in commercial law history. And this work is entitled Consuetudo vel Lex Mercatoria, or The Ancient Law Merchant, written by a Dutch merchant who emigrated to England and published many works on economic history, and this one on law. Well, scholars speak in this case about the new Lex Mercatoria. This new Lex Mercatoria has a similar definition, of course, but maybe we can use the definition by Francesco Galgano, who was a very important professor of commercial and civil law at the University of Bologna, especially. And he wrote that the new Lex Mercatoria is the law created by the business community, okay, so merchants in the past, without the mediation of the legislative power of the state. This is a very important point. And formed by rules intended to uniformly regulate the commercial relationships established within the economic unity of the market. Okay, here you have, with the new Lex Mercatoria, the market, okay? As well as for the new Lex Mercatoria, I would say that the most important features are independence from the national legislator and international uniformity. And this is a big point for me. So I would also like to underline that we should be aware that there is a difference and an ambiguity at the same time between Lex Mercatoria, which, as we have seen, can't be really found in the sources, and Ius Mercatorum, which, on the other hand, was the very expression used to define commercial law in the Middle Ages and the modern period. So Gerard Malines, our Dutch-English friend, who was a merchant, in the 17th century distinguished between them. Lex Mercatoria was a customary law approved by the authority of all kingdoms and commonwealths, while Ius Mercatorum was a law established by the authority of a sovereign. So on one hand, something customary made by merchants, a bottom-up approach, and then approved by the government. On the other hand, something established by the authority of a sovereign. But, and this is why we are still talking a lot about this, for example, Francesco Galgano, this contemporary lawyer, who wrote a book entitled Lex Mercatoria, uses Lex Mercatoria and Ius Mercatorum as synonyms. Okay, so tell me what
I'm
you are.
wondering about, no, because I'm very curious about this distinction between Ius Mercatorum and Lex Mercatoria that you mentioned. And these two facts that supposedly define the Lex Mercatoria as are the independence of the national legislature and the international uniformity. Because, I mean, if we are talking about custom and then we are talking about the law enacted by a sovereign, it seems that everything contradicts each other a bit, right? That there's no, and then you have authors that you're saying that they are even using the terms as synonyms. So I can imagine a person getting to these treaties and completely blowing their mind. Like what are they talking about?
Yeah, in fact, the problem of terminology is a huge one. So I am focusing my research on Lex Mercatoria, starting from the observation of these phenomenon of the use of these supposedly ancient expression by contemporary lawyers, because we have the new Lex Mercatoria. Now, people really, in the framework of legal studies, they know this expression. But this is why I mentioned the fact that in reality, we don't find it in the sources really. And especially in England, which is usually something a little bit, outside the history of continental Europe, linked to, the development of the universities and the study of Roman and canon law with a specific methodology. And this ambiguity of terminology and this confusion led me to try to approach this issue starting from the study of language. Exactly. This is what I'm trying to do, because law is made of technical legal words. Law is a language, in a way. I tell this to my students sometimes. What they are learning at the university in a law faculty is a language. They use common words in a technical way, like, for example, property. And what they are going to do with their clients as lawyers will be to translate their problems into this technical language. And so I thought that also for commercial law, this was a good point. So what I can say, in fact, studying the sources as an historian, is that Lex Mercatoria cannot really be found in the sources, and that Ius Mercatorum was, in reality, the generic definition of commercial law, which included both customary laws and, statutes. So focus on the words, focus on the sources. Ius Mercatorum was the term that we can find in the sources, which was more comprehensive than the concept of Lex Mercatoria as we find it in the few sources like Gerard Malines or today in contemporary literature. Okay.
Yeah. Yeah. No, I think it's very interesting what you're saying also about language and how important it is for law. I was reading the other day like something about legal knowledge and legal experts, and there's a term that I'm been super interesting at the moment that is epistemic community. The idea of like a community that has some technical knowledge, and they all share notions of shared validity. So in this case, the merchants, they share a technical language, and for them, this language has a validation that has a legal outcome. So I really like when I was reading your notes about this interview, because I thought this was very applicable to that. As merchants are also like a community of shared knowledge and shared
Yeah,
practices as well.
the point here is that in reality, analyzing the words were sometimes quite widespread. So words connected to commercial law, like bankruptcy or bill of exchange, in the form of a transplant, or a migration of terms, or a calc, cambiale in Italian, or lettera di cambio, which becomes bill of exchange, for example, or Wechselbrief in German. And usually the words emigrated from central northern Italy in the Middle Ages towards Northern Europe, not the other way around, at least in the past. Now we have English words in Italian, in the Italian legal system, for example. But in the Middle Ages, it was not like that, and also in the early modern period. So we have a strong influence of Italian, but in reality, when it came to really the technical meaning, there were differences, okay? And so it's not like Roman law. There is not
Yeah.
this uniformity that you have, I would say, when you have a political unity. So you have to think about the historical context, you have these mosaic of city states in the Middle Ages, but also, within the unity of the empire, of the Holy Roman Empire. Then you have all the different states, and so the unity of the Roman Empire brought to these uniformity of law to a certain extent. I know that there was plurality also. In the Middle Ages, we have the common background of Roman law in the sense of legal studies in universities, and this is super important. But there was this political fragmentation, okay?
Mm.
So that's why it's so difficult to really understand this topic of the Lex Mercatoria, because from a logical point of view, you would say, okay, they had to communicate, those merchants, they had to understand each other. So, okay, they had these common customs. But we will see maybe during this conversation that today legal historians, they challenge a lot the idea of medieval and early modern Lex Mercatoria. And of course, they support this opinion with evidences.
I have to say that I've been acquainted with the ancient Lex Mercatoria, and the new Lex Mercatoria is something that is a bit unknown for me, because I think it's mostly used in international law. That is basically a field that I don't really use that much. And I was wondering why to continue with that name, but I guess partly because this understanding of, like a common frame, and that there is a customary law that is, working everywhere or something. I mean, what will be like the understanding of the ancient Lex Mercatoria when they are using it in a modern context?
Yeah, I would answer using the words of Albrecht Cordes, one of the leading experts on the medieval Lex Mercatoria, professor at the University of Frankfurt. And he wrote that the expression Lex Mercatoria provides the robur antiquitatis, the vigor of old age, to the supporters of corporate self-regulation today. So the idea that there has always been a common, let's say, customary law independent from a state regulation provides these legitimacy of ancient things that, okay, that it has always been like that. And I think that it's quite true. And it's incredibly powerful, this idea, and how it is used today. So, considering again that it is not really used in ancient times. So, this
Yeah,
is,
yeah, yeah, yeah. Yeah, yeah, yeah. No,
strange.
it's very interesting how this concept can be powerful sometimes. Like with another guest, with Cliff Orando in another episode, we were talking about the notion of mores majorum. If you read the sources, nobody really knows what this means. They are only using it as an argument of authority. Like the ancient used to do it this way, but they use it for their own.
It's the same. It's the same to a certain extent, I would say. Even though there is some truth, okay,
Of course.
but it seems like a truth that cannot be contested, and even in the Universalgeschichte des Handelsrechts by Levin Goldschmidt, who is these experts of commercial law and commercial law history who wrote this introduction to another book, which became an independent book, and is his most famous work, published in 1891. He was the first chair of commercial law at the University of Berlin and in Germany in general. A super scholar, of course, educated on the basis of Roman law, who is still very much quoted today by especially commercial lawyers writing a historical introduction to books on commercial law today. But I mean, it's 1891. Now, very interesting. And also for political reasons, I would say he supported this idea of a kind of universal commercial law, but he was a very, very serious and interesting scholar, of course. But in Goldschmidt, as far as I know, the expression lex mercatoria is not used, or maybe few times, but I don't think it is used in the Universalgeschichte. So the universal history of commercial law. So he talks about universal history of commercial law, and he talks about this communication and the importance of the Italian city-states in the the Ages, and of the Hanse in Northern Europe, the network of cities. So talking about Lex Mercatoria, they quote Goldschmidt, but he didn't really talk about Lex Mercatoria. And there is even an Italian translation. The only translation I know of the Universalgeschichte is an Italian one. So you see how those concepts then they acquire their own life, so they have a life of their own, and they are detached from the sources at a certain point.
Yeah, but it's interesting because it seems that it means that they are still alive. I actually, I find interesting to trace that,
Yeah.
like this kind of different.
It, if I understand what you mean, I think you are perfectly right. And it's not because Lex Mercatoria is not in the sources that we must not be interested in what it is now and how it was interpreted, etc. So it's just the life of concepts that is something that reveals us something about the times we are living in, or something about the context. What is the interest in a certain period? What are the aims in a certain period? So in fact, I sometimes say that tracing the history of the concept of lex mercatoria is really tracing a history of commercial law, even if you don't have the expression in the sources, or if it's a myth, because it's a way to understand the different historiographical interpretations.
Hmm.
So, okay, I think it's more or less what you were saying.
Yeah, 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 yeah. But we have been mentioning, the word challenging, and I think we cannot talk about challenging Lex Mercatoria without bringing the name of a very important scholar, Emily Cadence, who
Yeah.
actually, published the idea like Lex Mercatoria is a myth. She obviously has, sparked she has sparked a significant debate, and she has, support and criticism. But I think her main points attack the idea of universal customary law and the independence of the lex mercatoria of state law. So, can you elaborate a little bit on that for the listeners?
Yeah, okay. You quoted what is probably now the most famous article on the Lex Mercatoria, and the title itself, it's very clear: the myth of the customary law merchant, the Texas Law Review 2012. And it's a very long, detailed article. So if you study the Lex Mercatoria, you have to quote this. It's impossible not to mention Emily Cadence. Now, here, a point is very convincing, and in general, legal historians nowadays, they tend all to deny the idea of the existence of this kind of Lex Mercatoria, like Albrecht Cordes or Dave de Royscher. But here, I would say that the definition is very important. So the definition is the one we mentioned at the beginning. Now, a universal and uniform customary law of merchants. Cadence wrote that this is a myth, so useful for the supporters of modern corporate self-regulation, for two reasons mainly. Because in the past, in the Ancien Regime in general, let's say, or in the Middle Ages, because she focuses on the Middle Ages, commercial law was mostly regulated by contracts and statutes rather than customs. And also, she underlines that customs were, and to a certain extent are, typically local. So it was very difficult to transplant a custom. And so, these international commercial transactions, they took place using contracts, using statutes, local statutes of the place where the dispute took place. They used local customs, often being helped by intermediaries. And this is very important to understand those commercial transactions in the past, the role of brokers. They were also translators, they knew local law. And I can give you an example, a very peculiar one, but is one that I know. In the Fondaco dei Tedeschi in Venice, which is a huge building next to Rialto Bridge, so in the very heart of Venice. So if Piazza San Marco is the center of the political power, Rialto is the center of the commercial activities. And you have this huge building which hosted the Fondaco dei Tedeschi. So it was a warehouse, at the same time a hotel for German merchants coming from a big area of Northern Europe. So it was very, very important for Venice, because all goods coming from the east, they and directly in the territory of the empire, passed through Venice, and also the other way around. Okay, and all the transactions had to be made at the presence of a broker called Sensale or Messeta, who had to know German and who was paid by the Republic of Venice. So it was a way to control. And so this was a way in which transactions were concluded, by means of these intermediaries. Of course, many German merchants, they stayed a lot at the Fondaco for years and years. So they learned Italian, but they had apparently to use these intermediaries. For example, Jakob Fugge, one of the most famous merchants in history, I would say, arrived in Venice very young. They did a kind of apprenticeship in Venice from Germany and stayed there for 16 years, and then went back and became, as someone says, the richest merchant in history. I don't know if we can say that, but So, I mean, Venice was an important place, and in this place, it worked a bit like that. And yeah, anyway, Venice is a peculiar case because of the peculiar legal system of Venice, so outside the jus commune system. But for commercial law matters, it's a good example for Europe in general, I would say.
Yeah, I like that you quote as a good example the Fondaco dei Tedeschi, because Fondaco, I think, is also like a very technical term in the context of commerce, right?
It's of Arabic origin. In Northern Europe, we have Kontor. It's a model of warehouse that is widespread in the Levant, okay? And then the word arrives. This gives you the idea, in fact, of the migration of terms of these merchants traveling, etc. Even the architecture is different from anything you have in Venice. So it's I like very much to do this kind of interdisciplinary reasoning, between law, language, architecture, art, because law is part of our culture. Is maybe a point of view from which we can interpret reality and history. It's not something separate from the rest of our lives. It's in our lives every day, everywhere. Okay.
Yeah.
So no one can say, I don't care about law. Unfortunately, we are all completely overwhelmed by rules, not only legal rules, but
Yeah, of course. And then there's this notion of multinormativity where we have all these implied, like ethical norms and social norms and all this kind of thing. But
And I think, if I may, that this is a very interesting point of view when we come to talking about Lex Mercatoria. And I like very much the interpretation of the Lex Mercatoria as a culture of merchants. I'm not inventing it because this is, if I'm not mistaken, point of view of Carlos Petit, professor at the University of Huelva, who is another leading expert on the issue of Lex Mercatoria. He talks in reality specifically of the la cultura del ius mercatorum, but in this case we can, generally speaking, about commercial law culture, or in the sense of these different normativities. So I'm not really challenging the idea of a lex mercatoria in this sense. I am otherwise supporting this because those merchants, they understood each other. They communicated in some way. So when it came to technical legal problems, then they applied usually the local laws in a local tribunal. Maybe there were some customs that were used in a broader area, but anyway, it's more like this, or on the base of contracts or on the base of arbitrators that were chosen by the parties, etc. But there was something like a common mercantile culture that was made of several kinds of normativities, moral ones, moral rules, religious rules in Europe, in the Christian world at least, behavioral rules, that were recognized by merchants all over Europe and not only, and also to a certain extent, legal rules, so which were only part of these. And there was kind of even broader culture with a set of notion, information about geography, for example, or history that you can find, for example, in the books, in the manuals of merchants on that circulated a lot and were a lot on, the different, the geographical areas, the routes they had to follow, or the different kind of goods and the prices of the goods, and these kind of things were even written down and circulated. And there were these international environments like the Fondaco in Venice, where you can find people from many different parts of Europe. And Venice itself was a melting pot. So people had contacts. And so, of course, there was this exchange of knowledge.
And I was wondering because, of course, when we think about medieval commerce, I think a lot about guilds that you have mentioned before. Until what point guilds also have their own kind of rulings, like the way to organize themselves to conclude their contracts, and until what point the importance of guilds could have also feed up this idea of lex mercatoria as a form of self-regulation, in the idea that maybe guilds, could work on their own in a way because they were important.
I mean, guilds are part of this system of the Lex Mercatoria, if we want to accept it, absolutely fundamental in the Middle Ages. All over Europe, I would say. So guilds that had their own statutes, their own tribunals, and in this sense, independent from the state power, let's say. But it's not so easy, even in this case, because guilds became so powerful that they were part of the establishment in a way in some cities, in Florence, in some Italian city-states that I know better, in some cities that the merchants were so important that guilds were less important and they were directly part of the establishment, like in Venice or Genoa. So, theoretically, you can make this difference. Guilds were independent, and in some cases it was like this. There were general guilds like the Mercanzia. An example is also Perugia, where the Mercanzia and the Guild of Money Changers were really powerful, but they were also part of this government establishment in the course of time. So in the course of the Middle Ages, going to the modern period, there were changes in this sense. So this independence, which is part of this corporative mood of the Middle Ages in the theory of Francesco Calasso, this is what characterizes the origin of the Italian comuni, the spirito associativo. It is very typical of the Middle Ages, these oaths people made to join, and is evident even in the birth of the universities, the Universitas Studiorum, it's an association of students. Of course, with the development of the state, of the modern state, these changes also in relationship to commerce. So we have, I would say, we can think about other legal formats, to use the words of Rodolfo Sacco, for example, legal literature and judicial decisions, and not only legislation. And these changes in the modern period. So, for example, we start to have an interest by learned doctors of the civil law for commercial law matters, because in the Middle Ages they were not in the radar of interest of civilians, only in some opinions, for example, by Baldo, they are quite famous. But we have the first work on commercial law in general only in 1553, published by a lawyer, a doctor of civil law, called Benvenuto Stracca, and the title is De Mercatura Seu Mercatore. And in the same period, we have the development of what we call in Italy grandi tribunali, the great tribunals managed by the state, and they were of two kinds. The rote, they had judges who were lawyers, who were doctors of civil law or studied at the universities, and there was a compulsory motivation. And so the sentences of these great tribunals were then printed, and then they circulated all over Europe and gave also a further uniformity to this jus commune system that lasted for so many centuries because it changed in the course of time. And the Rota of Genoa, an important commercial city, of course, was the first one who included also commercial law matters in this great tribunal, and the Decisiones de Mercatura were printed, and so they circulated as early as 1582. And then also the legislation started to change because it became less and less monopoly of these corporations and more monopoly of the state, even though there was always a kind of mixture. And the most important example is the Ordonnance du Commerce of Louis XIV, 1673. And then we go slowly towards codifications. Okay, so I mean, it's a long period, so of course things changed, but the idea of transnational understanding of people involved in commerce that are interested in especially in being quick in the resolution of disputes. This is something that is real and can be found in the course of centuries until today. Okay, from a procedural point of view, there is this interest in not being formal, in being quick, in being effective, using arbitrators. Maybe it's something useful and therefore common yesterday and today.
That was a really good excursus and shows how complex the topic is, and increases my admiration for people who works in medieval period, because I always think that, yeah, as you said, in the Roman period we have at least an anchor. But then I would like to go more towards your project, Miko. I would like you to, if you can, give an overview of exactly what you're doing and how it challenges or engage or like with these debates on Lex Mercatoria that we have been talking about, actually.
So, as I said, legal historians nowadays tend to deny the existence of this Lex Mercatoria, and I wanted to approach the issue in a fresh way. And so, what I'm doing, my methodology, is trying to understand the history of commercial law by means of the tools of historical linguistics. So, I'm trying to follow the words. Like they say, follow the money to understand things. I'm following the words and the money to a certain extent because we are talking about merchants, and trying as far as I can to let the sources speak. So I'm not really challenging this idea of Lex Mercatoria if we define it in the way I was talking before, the Carlos Petit interpretation, like a soft law, we could say, okay? Because studying this migration of words, we can say that it is true that words migrated and were used in different contexts, in different languages. And so, what I'm trying to create is a historical lexicon of commercial law. It took like 4 years to understand how to do this and how to choose the words and how to be useful in a way. So finally, I think we are at a good point. So what we are doing now is this. We chose few words and the synonyms. And if you have the few words plus the synonym, in reality, you have already, so, and the connecting terms, for example, all terms connected to the crisis of the business, then it's not a few words, but we will give quite comprehensive explanations. So my reasoning was this. I decided to isolate, in a way, the terms connected to 4 big categories that I think characterize the so-called commercial revolution of the Middle Ages, of the late Middle Ages. So this commercial revolution that Roberto Sabatino Lopez made famous, that went hand in hand with the development of the city-states in several parts of Europe and the development of urban economy. And now even the idea of commercial revolution is challenged, for example, by Chris Wickham. But I think that from the point of view of law, something really changed in this period. And we can observe this analyzing these 4 categories. The first one is collective forms of business activity. So let's say company, so societas and compagnia, for example, in Italian. And then the second one is new contracts with reference to Roman law, for example, insurance, so something that didn't exist before. And then payment instruments, so especially the bill of exchange, lettera di cambio. And finally, the crisis of the enterprise, so bankruptcy and so on. Now, I want to underline that I am not forgetting about Roman law. So I don't want to talk only about customary laws and the merchants that are independent, etc., because Roman law was there in the Middle Ages. Notaries wrote the contracts, they knew Latin, and in general, commercial law cannot be understood without the support of civil law. I mean, it's always an exchange. It's not something, a system of rules which is independent from civil law. You have basic contracts like the emptio venditio, like the selling of goods, which is the most important contract for merchants, because the main activity is buying in order to resell. This is the most important activity of a merchant. And this is something that you have in civil law, of course. It's not something peculiar. Buying in order to resell can be a specific contract, but as far as I know, it became like this only in very recent years, 19th century, okay, with specific features. So what I want to say is that I am very aware of this Roman background in the interpretation of, the Middle Ages and of the modern period. It is there. It gives, to a certain extent, a common legal framework, but it's not enough. It is true that there were merchants' customs, that were merchants' peculiarities and merchants' tribunals, etc. So it's a mixture. And why those specific institutes and the connected terms? Because they represent something new with reference to Roman law. So there was a societas, of course, in Roman law, but in the Middle Ages and then in the modern period, it became so different, going towards the autonomy of the capital in the modern period, for example. So the legal personality of the business company, but also many other features. So the new things were so many that we can say, okay, it's groundbreaking. Contracts that didn't exist, insurance, so it's groundbreaking. Payment instruments, bill of exchange, didn't exist, groundbreaking. Bankruptcy in the medieval sense, that is what then developed until today, because in Roman law there was this cessio bonorum, but was kind of negotium between private people. It was not compulsory. It changed very much in the Middle Ages in the new political framework of this medieval fragmentation. And so we are giving a picture of the migration of the words throughout Europe using existing historical lexicons, because we cannot do all the work in a few years. For example, one of our sources is the Deutsches Rechtswörterbuch, and consider that they are working on this. They have been working on this for 135 years now. One of the founders was Otto von Gierke. So in 5 years, we cannot do. So we are using the historical lexicons, which give a big picture. And then we have a case study. And the case study refers to the relationships between Italian and German merchants, 11th, 17th century, using 4 kinds of sources: statutes, contracts, letters, which are an interesting source, and treatises, which are a few on commercial law. And so we are establishing a model. The idea is this one. We are going to produce a historical lexicon of commercial law for 3 languages: German, Italian, and Latin. And this is another problem, because usually linguists nowadays, they don't deal with Latin, they deal with vernaculars. And then in the future, someone else can do French or English or whatever and multiply the case studies. So maybe in 100 years, like they are doing in Heidelberg, there will be a big work on this, and maybe we could give other answers to the question of Lex Mercatoria. Maybe.
Yeah, it's good. You can expand even to, well, Dutch, I imagine, as well, and Spanish, maybe.
But even to the entire world, this
Yeah.
is the idea. You could go to South America, or I don't know, maybe considering a different time frame. No, I would like to cover all the languages of Europe at least.
Yeah, yeah. Well,
So,
yeah, you're
uh,
gonna be busy then.
no, not me. I mean, someone else. Maybe I can do another one, but not many.
But also because you then expand to the modern era, because if you talk about the Hanseatic League, then you go towards the north, and then you include other languages of the north, and then yeah, it's great. You're not gonna be bored at all.
No, no, not at all.
No, but what I will be interested as well is because, okay, you mentioned emptio benditio, and I will be interested to see, what categories of Roman law do they use in their documents? Like, for example, if they have things as a receptum nautarum, as the custody, the safekeeping of the goods when you put them on board as well, or the maritime laws, fenos nauticum. Well, obviously, there's the problem of jettison.
You opened the door to the problem of maritime law,
Yeah.
which is, of course, huge. And in theory, in my project, I wanted to focus on Italy and Germany. So excluding maritime issues and, because I'm focusing on these terrestrial commerce and the routes, because the other output of my project is or are the interactive digital maps of the trade routes of merchants, and the routes by sea are more studied, I would say, and the roads they follow it, including the waterways, canals, rivers, etc., are less studied, or not so easy. It's not so easy to find information. So I'm reconstructing these routes, and my idea is to mix, put together the maps and the lexicon so that it will be possible to see where the words, diffused. Anyway, the maritime law, this is an issue. Usually, it is considered part of commercial law, and also in the ancient sources, of course. In some cases, there is much ambiguity. So, for example, the contract of commercial law in the Middle Ages is the commenda, which I will treat as part of societas, in the sense that I will, in this part, devote it to the collective organization of the enterprise. No, and it's super studied. And of course, I have to take into account, but it was mostly used for maritime commerce. But I cannot avoid this. So, it's not really possible to avoid maritime law when it comes to the history of commercial law, of course. Roman law is there, but it is true that they developed customs usages based on the decisions of the tribunals, and so I don't have an answer to this. The role played by Roman law. But one thing I can say, or two things. Notaries wrote contracts, and they knew some Roman law, and they based their contracts on formularies, etc. So, and also there was a contact with the doctors of the learned law. These were, we have to put merchants in their historical context. I mean, Venice was proud of her autonomy, and the merchants, they did their own business, and Venice itself had her own law. But the University of Padua, where I am teaching, is like 30 kilometers away, and it was the University of Venice since 1222. Okay, so it's not another word; it's completely separate word. First, and then what happened in the modern period is that when they started to systematize commercial law, and in the same period, the state started to get a more interest in controlling commerce and commercial legislation. Well, who did this were people who studied Roman law. Benvenuto Stracca in the 16th century, Johannes Marquard in the 17th century. And of course, you can rely on merchants tribunal sources or things like that, but you studied Roman law, you have these categories in your mind, so you cannot avoid this. So when they started to systematize commercial law, they use the Roman law categories to a certain extent. It's not possible to think otherwise. And so, and then the history goes on until the codifications. So the role of Roman law must not be underestimated. And I would say that especially economic historians writing about Lex Mercatoria, they forget completely about this.
Yeah.
I don't know if you, because I know you
Yeah, yeah.
studied if you have this impression, but you
Yeah.
know,
Oh, no, I totally have. I think there's, as we said before, there's kind of like a separation between ancient, Roman, legal historians, and then I feel like we get to late antiquity, this kind of like bridge between periods, and then you start with what we call in Spain historia del derecho, so legal history, as called as like, and you start with the medieval, and there's no there, even though the legal historians in Spain, they start with the Visigoths, and Visigoths also use Roman law. So it's like I don't really understand the
you
separation
use
that
it a
much.
lot, but you know that for example, I'm coming from a school. I study in Rome from this tradition of Francesco Calasso, Ennio Cortese, Emanuele Conte, and we start from Constantine the course. But I know that some other people they don't do this very long period because I start from Constantine and I arrive to. I mean, in my course of legal history, I arrived to the codifications. Or the German law school, the historical, okay, how is name in English, the Scuola Storica Tedesca, okay,
Yeah,
examens,
yeah, yeah.
etc. For me, it's super important this because with Constantine, you have the first Christian emperor, and this is a huge change. And then also all, Justinian things, the students in theory, they study Justinian in the Roman law course, but they have to be sure that they really know how the corpus juris was divided and was created, because what is the absolutely crazy things a thing is that centuries later, a guy called Irnerius started to teach those ancient books, putting them together. And Odofredo wrote, if I'm not mistaken, Studendo Cepito Cerit. So studying, he started to teach. And this is, and so if you don't know really about late antiquity, you don't understand what happened in the Middle Ages, and then you
Yeah.
don't understand how Rome influenced modern codification. So that's why in legal history courses, especially, we do, at least in Italy, a very long period, which is a bit crazy for historians, in general historians who divide Middle Ages and modern period a lot. But to understand a phenomenon like law, I think you need the long period, and also the High Middle Ages. And the
Yeah,
Visigoths,
yeah.
they had good books of the Lex Romana Visigotorum. It's not comparable to other Germanic laws, which were not so sophisticated.
Yeah, we're
History
derailing a
of-
bit. No, I would like to go more on your on what you're doing, the work of your project, because I know that you're recording a film now. I would like to know how, what is this project about? Because it's very innovative. We normally don't do that much outreach. So great.
Yeah, I have to say that one of the reviewers of my ERC project was a bit skeptical. They are maybe not in legal history, in economic history, etc., documentaries. And this was my idea at the beginning, even though I would say that in legal history, it's not common at all. Anyway, there was an international competition to choose the director. I wrote the subject, let's say, with the help of my team. But in reality, the proposal that was the successful one was very original, proposing not a documentary, but a real movie with a story. Because, okay, the main aim, and it was one of the characteristics of the competition and of my year's project, one of the aim of the movie in particular is dissemination. So reach an audience of people not belonging to the academia, and especially young people. So at the end, we thought that a documentary would be of interest, especially for people already interested in these kind of issues. So the challenge was to reach an audience of young people. So we created a story, and within the story, which is set in Padua, in a school in Padua, inserted, the interviews and also even quite technical details about the commercial transactions of merchants, especially German merchants in Venice. So the core of everything is the Fondaco dei Tedeschi. And the title of the movie is Le Vie dell'Acqua, Waterways, because we focus a lot on the role of water, especially internal water, but also the sea. So the canals and the rivers and the lakes in the past until a very recent period for, the development of commerce. And the director is Fabio Masi. And we are shooting in this period. We did the shooting in Padua and Venice at the university, etc. And now we are finishing, and I'm very happy about this. And I hope it will be ready for September. And the idea is especially to show it in high schools and universities, hopefully all over Europe. So this is really a challenge, but the team was great. And we will see. You certainly will be informed about this.
Yeah, that would be great. I have to say, as a secondary note, that Stefania also gave a talk in the other STEM webinar I have been collaborating since 2020, Down by the Water, Global Conversations in Maritime Archaeology, exactly about the roots of this film project because we're talking about rivers, actually, and development of rivers.
You are right. I forgot about this, but it's true. And then now I'm finding maps. I found a very interesting map, a late one, but on the roots of commerce in the archive of the mercantile magistrate of Bolzano, end of the 18th century. And but it's interesting because it's a map about the roots of commerce and very unique from central Italy to Augusta, Augsburg in Germany. And the waterways are super important in the map, are like the most important thing. And so this gives you an idea of this importance of water. When I talked within your webinar, I was at the beginning. Now I have more concrete ideas of how it worked. And another thing, just to add something, it's incredible how in the past man changed the waterways. They did incredible works in the area of Venice. Of course, everyone knows that Venice is built on water, but maybe we underestimate this. And I am really challenging a lot the idea of the Middle Ages like a dark period, which is, of course, nonsense for historians. But here, in this area where I'm working, Venice, Padua, Northern Italy, we have the foundation of the universities, we have commerce, and we have these incredible, incredible works to create canals, change the course. There are canals. There is a canal here nearby Padua, the Canale of Battaglia Terme, Canale Battaglia, which is a straight artificial canal. It was built in the 1190s, at the end of the 12th century, and it's still there. I mean, and it was used for commerce until yesterday. So just to provide an example.
So we shall invite you a second time then to give the final product. Maybe we can do like a film discussion or something like that. We do sometimes book reviews, but film discussion will be something new. So, but yeah, I have like still enough of your time, Stefania. Thank you very much. So I would like to just to finish asking, where can we find the work of Miko, the work you're developing, to keep in touch?
Okay, thank you very much. Of course, we have a website, which is www.micol with 2L dash ERC.eu. But if you Google Micol with 2L or my name, you will find it very easily. And you have a lot of information, news, events, conferences, etc. But of course, the publications of all the team members that are open access, of course, because it's the rule of the ERC. And in the future, also the lexicon and the maps will be accessible from the same website. And also we have social media, especially Facebook and Instagram. Also YouTube, but we are working on this. So anyway, okay. So I hope that the website is quite clear and yeah, the information are there.
Yeah, I think we have enough to work on and to think about. You have really, like talk about many different topics and many exciting discussions on the field. So again, thank you very much for being here.
Thank you.